Michael McDonald versus Warden William Gitteri, case number A-21-832-354-W. This is on for argument. I did read I attempted to read the pro per motion. I did read the supplement. I did read the return. I understand there was a reply that I didn't get to see, so I have not seen that because it just got filed yesterday.
I do have a copy of it.
I have a copy of it, but I
okay.
just don't have time to read it before.
I can make the representation.
Okay, so go ahead, Ms.
Well, Your Honor, there's basically two main issues in this case. As you know, Mr. McDonald was convicted of 5 counts of illegal wiretapping. And in order for there to be a count, there has to be one communication. So you can't have one communication and 2 different recordings of it, or one recording that's been spliced into 2. That would not be 2 counts. That would be 1. If you look at the jury verdict, the jurors were asked to first determine if, for each count, which represents a recording, first determine if that recording represented a separate communication from all the others. And the next question they were asked for each count was, is Mr. McDonald guilty of that count? For counts 1 and 5, the jury found that those 2 counts were not separate wire communication. Since those are the only 2 out of the 5, that would mean that those 2 are from the same, those 2 recordings are from the same communication. The issue is that they checked not guilty on one and guilty on the other. Count 1 was the count that the jury came back with a not guilty on. So, this argument was made on appeal. It was not made in district court, either moving for a mistrial, questioning the verdict form, asking for a directed verdict. And so it was not preserved for appeal. It was then raised on appeal, and the Supreme Court noted that it was not raised down below and that it would require plain error analysis, but appellate counsel did not argue plain error analysis. Counsel argued that it was properly preserved, which it was not. So that's the basis for one of the claims in Mr. McDonald's petition. The other claim is that trial counsel did not conduct proper investigation and was ineffective for failing to do so to look into getting evidence in the form of testimony and other documentation showing that Mr. McDonald was in California at the time that these calls were made. If he was in California at the time these calls were made, pursuant to Supreme Court case law, he cannot be guilty of illegal intercept of wire communication. I did attach a declaration from the witness that I believe trial counsel should have called. His name is Scott Bradley. He was with Mr. McDonald in California during this time period. There's definitely a factual dispute. Ms. Ruiz, Mr. McDonald's ex-wife, the person who's on the other end of the call that was recorded, she says that the calls occurred in October and that Mr. McDonald was here. Mr. McDonald claims the calls occurred in August and that he was in California. So there is a factual dispute. There was no other evidence to prove when these calls took place. At trial counsel, there was some discussion between Mr. Mueller and Ms. Mishler regarding this witness, Scott Bradley. It was known that there was a chance that he would call him, but trial counsel did not put Mr. Bradley on the notice of witness list. That was discussed at the beginning of trial. Mr. Mueller then said that he attempted to contact Mr. Bradley and couldn't get in touch with him. I had no problem getting in touch with him. Texted him, he wrote me right back. We talked on the phone. I even spoke to him this weekend about signing the declaration, and he called me from baggage claim in the Philippines. So he is not difficult to find. He was very cooperative with me. There was nothing on the record that suggests what attempts trial counsel made to locate Mr. Bradley. And I think that had he been able to testify, it would have supported the defense theory that Mr. McDonald was not in Nevada at the time those calls were made. Based upon all that, I do think Mr. McDonald is entitled to a new trial and at the very least entitled to a without appeal. And with that, I'll submit.
Miss, what, Karen? Oh, Mishler. Okay, I was saying Ms. Mishler.
Thank you, Your Honor. And first, I think this was just an inadvertent misspeaking, but I just want to clarify. Mr. McDonald was only convicted of 2 counts of wiretapping. He was acquitted of 3. He was found guilty of counts 2 and 5. And regarding and I addressed this in my response, and we could speculate as to what the jury found in terms of the form, but ultimately there was no double jeopardy violation here because double jeopardy prohibits being punished multiple times for the same conduct. And the defendant was found guilty of 2 counts and his sentences were imposed concurrently. So there's no double jeopardy violation regardless of what sort of argument you want to make about the verdict form. So it's clear that Mr. McDonald was not prejudiced from any failure on the part of counsel to argue a double jeopardy violation. He would not have been able to obtain relief on that claim. So there was no double jeopardy violation here. Regarding the allegation that counsel was ineffective for not presenting testimony from Mr. Scott Bradley, nothing has been presented establishing that Mr. Bradley would have been able to provide any information regarding when these calls were made. So Mr. McDonald's ex-wife, Candace Ruiz, testified these calls were made in October. And if Mr. Bradley had testified that Mr. McDonald was with him in August, that wouldn't have done anything to refute that testimony. Further, I attempted to find out some more information online about what this Money in You seminar even is. I couldn't really find much out about it. It seems unlikely that Mr. McDonald was at this conference for the entire month of August 2016, particularly considering I was trial counsel in his other trial. I know he was employed at the time in Nevada, so that seems unlikely. And then regarding the allegation that Mr. Bradley could have testified regarding Candace Ruiz's credibility and her truthfulness or lack thereof during the family court proceedings, I don't believe this testimony would have been allowed. I would have objected strenuously. If the court had been remotely inclined to hear such testimony, I would have extensively voir dired him outside of the presence of the jury. This NRS 50.085 allows for testimony regarding one's opinion of the truthfulness or lack thereof of another witness, but that's still subject to the requirement of NRS 50.025 that the witness has to have personal knowledge. I've seen nothing that indicates Mr. Bradley has ever even interacted directly with Ms. Ruiz. So I don't think any prejudice has been shown for either of these claims, and for that reason, I think this should be denied. Just on their face, there's no indication that there was any prejudice, and I don't believe an evidentiary hearing is necessary.
Thank you. A couple of things. As far as the dates go, we're not arguing that he was at the Money for You conference in California for a whole month. He specifically remembers making those calls while there. Mr. Bradley can support testimony that my client was there with him. Mr. Bradley also knows that my client was communicating with his ex-wife through an app. More details can be provided at the evidentiary hearing, but I think it's important to remember Ms. Ruiz couldn't give exact dates either. It was just sometime in the month of October. There were no exact dates. So to hold my client to that burden, I think, is a little bit unfair when Ms. Ruiz couldn't provide.
But he didn't testify, right?
He did not testify.
Right. So then
right.
Hers is the only thing that we've got.
And I'm going to get to that. Had trial counsel been able to obtain some independent evidence in the form of Scott Bradley testifying, and also providing a photograph showing that they were both there at this conference on those dates. It's on Facebook, so it's date stamped. At that point, Mr. McDonald would have been willing to testify, but without that, he felt that there was no supporting evidence, and it was his word against her word. As far as Mr. Bradley's proffered testimony about her character, he was present for a lot of the hearings in family court. He also watched a lot of them on video because they were all publicly posted. So, and he's aware of the things that she said, and he's aware of what kind of father Mr. McDonald was. Some of the things she said about the things Mr. McDonald did and didn't do with his children were untrue. And he could testify to that because he was there witnessing Mr. McDonald being a father. He was there with him and his kids quite a lot. With respect to the verdict form, it's not just a double jeopardy argument. It's also just a basic ineffective assistance of counsel argument for failing to properly word the verdict form. This was a verdict form that deviated from the standard form. It was discussed. Trial counsel could have said, listen, there can be an issue here if there's two counts that appear to be recordings of the same communication, but the jury finds guilty on one, not guilty of another. There's another way that this could have been dealt with. And then once the jury came back with their verdict, and this is what it was, it's clear that there's something wrong with it. It's clear that it's inconsistent. And as a result, Mr. McDonald has an additional felony on his record. So, you know, it's not possible for there to be two recordings that are part of one that's been spliced of one communication, and he's guilty of one and not guilty of the other. That's not possible. So
it does seem possible, because if they're saying that they're both the same thing and he's guilty on one, then they're saying that the other one is not guilty, because, I mean, you can't have two. So there is a...
But that's not what they were asked to do, though. They were asked to only say whether or not it was an independent communication and whether or not he was guilty. They were not asked to then determine, well...
But if they did, then it's still possible.
If they did what? I'm sorry.
If they did determine that only one of them counts. I don't know what all of the jury instructions said. And so if there's one communication, they're not giving him two verdicts. They're giving him one verdict on the one that he's guilty on.
Right. That's asking the jury to interpret a jurisdictional issue, which they're not entitled to do. I also argued that this should have been dealt with in a motion to dismiss. Well, not this aspect, the aspect with Mr. Bradley, but it all should have been dealt with in a motion to dismiss as well, with respect to Mr. Bradley's testimony. With respect to the verdict form, I think that, I mean, obviously it's an issue that counsel thought was relevant because he raised it on appeal, right? He did raise it on appeal, but he didn't argue plain error. And there's no excuse for that. I mean, there's no strategy there. That's just ineffective assistance of counsel. It's negligence. You have to argue plain error if it's not preserved down below. So at the very least, I think Mr. McDonald's entitled to a Lozada appeal on this issue.
I tend to disagree, but I'm sure you'll take it to the Supreme Court.
anyway, they'll hear it regardless.
Yeah, so this is going to be denied. Ms. Mishler, would you please prepare a detailed order so that when it does go to the Supreme Court, it says something more than just denied, because...
Yes, Your Honor.
And just to get some clarification for the findings, what is your ruling on the appellate issue that it would not have prevailed on appeal?
On the one about the double jeopardy?
About the verdict form. Well, it's not just double jeopardy. It's a variety of legal arguments. But with respect to the verdict form, yes, is that it would not prevail?
It would not have prevailed.
Okay, and then
as to the investigation, I just don't think that there is enough information. I don't think that there's even enough information to warrant an evidentiary hearing. I mean, if trial counsel said he couldn't find him, just because you've been able to years later doesn't mean that he was able to at the time. And so I just don't think.
Well, and I guess that's where an evidentiary hearing would shed some light on this, because according to my client, he did give the same number to trial counsel that he gave to me, and Mr. Bradley says that he was never contacted. So, and that's part of the standard that's required in Molina, is that I have to show how a better investigation would have changed the outcome. Oftentimes, I find things in post-conviction cases that other attorneys didn't, right? I feel like if I can find it, unless the state can show that it was not possible for Mr. Mueller to find this person, or this person was being uncooperative, which we don't know right now here today. I mean, I've talked to Mr. Bradley, but there's no evidence in front of the court because we haven't had an evidentiary hearing. But unless there is some reason why Mr. Mueller couldn't find him, I mean, it doesn't make a lot of sense to me why I was able to. And if I'm able to do that investigation, why couldn't it have been done previously?
Right. I see what you're saying, but I just don't think that there's enough information to warrant an evidentiary hearing. And so,
okay.
Ms. Mishler, please prepare the order.
Yes, Your
And
Honor.
send it to the department inbox when you get a chance.
Yes.
Thank you.
Nice to
Thank
see
you, Your
you,
Honor.
Ms. Schwartzer. Nice to see you, Ms. Schwartzer.
Just